With me this morning are Commissioners Brown Bland, Gladfelter, Duffley, McKissick, Hughes, and Kimmerite. I now call for hearing docket number E2 sub 1300, which is the application of Duke Energy Progress LLC or DEP for an adjustment of rates and charges applicable to electric utility service in North Carolina. Beginning on May 4th, 2023 and continuing until May 16th, 2023, the Commission conducted a hearing for the purpose of receiving expert witness testimony regarding the application of DEP for an adjustment of rates and charges applicable to electric utility service in North Carolina. On June 7th, 2023, DEP and the Carolina Industrial Group for Fair Utility Rates 2, or SIGFR, filed an agreement and stipulation of settlement, to which I will refer to as the SIGFR Partial Rate Design Stipulation. On June 9th, 2023, multiple parties to this proceeding, including DEP, SIGFR, and the public staff, filed post-hearing proposed orders and briefs, as they had been requested to do at the close of the expert witness hearing on May 16th. On June 27th, 2023, following the completion of the public staff's audit of DEP's final update, the public staff filed the supplemental testimony of Jeff Thomas, the second supplemental testimony of David Williamson, and the joint second supplemental testimony of Finge Zong and Michelle Boswell. Also, on June 27th, DEP and the public staff filed an agreement and stipulation of partial settlement, which reflects the completion of the public staff's audit of all of DEP's filings in this proceeding, including all supplemental filings, and is a full resolution of such audit with the exception of the unresolved issues previously identified in the initial revenue requirement stipulation between DEP and the public staff. In addition, also on June 27th, the public staff filed the joint supplemental testimony of Dustin Metz, Finge Zong, and Michelle Boswell supporting that stipulation. Finally, also on June 27th, the public staff filed a motion for leave to file the testimony of David Williamson addressing the SIGFR partial rate design stipulation. On June 28th, 2023, the public staff filed corrections to David Williamson's second supplemental testimony. On July 3rd, 2023, SIGFR filed a motion to strike and request for relief, taking issue with a second supplemental testimony of public staff witness David Williamson as it relates to the public staff's apportionment of the revenue requirement across customer classes, requesting that the testimony be struck from the record, or in the alternative, that the Commission allow discovery on the testimony and reconvene the expert witness hearing to allow for the cross-examination of witness Williamson. Also on July 3rd, SIGFR filed its opposition to the public staff's motion for leave to file the testimony of David Williamson related to the SIGFR partial rate design stipulation. On that same date, DEP filed a letter regarding the supplemental audit testimony of David Williamson and the SIGFR partial rate design stipulation testimony of David Williamson. On July 5th, 2023, the North Carolina League of Municipalities filed a letter regarding the supplemental audit testimony and SIGFR's motion to strike. On July 5th, 2023, the public staff filed a response to SIGFR's motion to strike David Williamson's second supplemental testimony. On July 6th, the Commission issued an order on these various and sundry post-hearing motions, which first denied SIGFR's motion to strike David Williamson's second supplemental testimony. Second, denied the public staff's motion for leave to file David Williamson's testimony related to the SIGFR partial rate design stipulation. Third, reconvened the expert witness hearing for today, July 24th, 2023. Identified the very limited issues upon which cross-examination may be conducted in this hearing as follows. A, the results of the public staff's audit of the final update to test year costs for the period of March 1 through March 31, 2023. B, the mathematical calculation of the assignment of the public staff's proposed revenue requirement in individual customer classes. C, the use of the public staff's principles to determine its final recommendation in this proceeding. And D, the SIGFR partial rate design stipulation. The July 6 order directed the public staff to present David Williamson for cross-examination and directed DEP and SIGFR each to present a witness for cross-examination in support of the SIGFR partial rate design stipulation. As I'm required to do by the State Government Ethics Act, I remind all members of the Commission of our duty to avoid conflicts of interest and inquire at this time if any member of the Commission has a known conflict of interest with respect to the matters coming before us this morning. Okay, no conflicts have been identified, so we will proceed. All right, we are going to tackle the issues in the following order. First, we're going to hear from witnesses on the SIGFR partial rate design stipulation, and then we will get to the public staff's assignment of revenue across customer classes as reflected in David Williamson's corrected second supplemental testimony. Before we begin, I will call on council to see if there are any preliminary matters to be addressed, and I will start with you, Mr. Jurak.
Thank you, Chair Mitchell. With your leave at this time, the company would like to move into the evidentiary record at the appropriate time. The two stipulations that you referenced at the start of this hearing. The first one being the supplemental revenue requirement stipulation filed on June 27th, 2023 between the company and public staff. And the second stipulation being the partial rate design settlement filed on June 7th, 2023 between the company and SIGFUR 2.
All right, Mr. Jurak, having heard no objection to your motion, I will allow it. The SIGFUR partial rate design stipulation and the supplemental revenue requirement stipulation will be admitted into the record.
Thank you.
All right, Mr. Josie.
Thank you, Chair Mitchell. The public staff would move the joint second supplemental testimony of public staff witnesses Finn Zhang and Michelle Boswell filed on June 27th, 2023, consisting of 6 pages and 3 exhibits into the record.
All right, the second supplemental testimony of DEP witnesses Zhang and Boswell filed in the docket on June 27th, 2023, consisting of 6 pages, will be copied into the record as if given orally from the stand. The 3 exhibits to that testimony will be marked for identification as they were when they were pre-filed. And Mr. Josie, I would ask that you remember to move those in. Actually, without there being no objection to your motion, move those exhibits in. I'll admit them into the record at this time.
Thank you. Public staff would also move the supplemental testimony of public staff witness Jeff Thomas, also filed on June 27th, 2023, consisting of 13 pages with confidential information and 1 appendix.
All right, the supplemental testimony of public staff witness Thomas, filed in the docket on June 27th, 2023, consisting of 13 pages, will be copied into the record as if given orally from the stand. That testimony also includes 1 appendix. The testimony also includes confidential information, which will be treated as confidential in the transcript. I ask that you confirm that treatment with the court reporter, Mr. Josie.
And then the public staff would also move the joint supplemental testimony of public staff witnesses Dustin R. Metz, Finn Zhang, and Michelle Boswell, filed June 27th, 2023, consisting of 6 pages and no exhibit.
All right, the hearing no objection to your motion, that testimony of DEP, or I'm sorry, public staff witnesses Metz, Zhang, and Boswell filed on June 27th, 2023 in this docket consisting of 6 pages will be copied into the record as if given orally from the stand.
And would the chair like me to move into the record David Williamson's second supplemental testimony?
Please do.
The public staff moves that the second supplemental testimony of public staff witness David M. Williamson, filed June 27th, 2023, consisting of 9 pages, be entered into the record, and his 3 exhibits as corrected by the June 28th, 2023 filing be marked as pre-filed.
And Chair Mitchell, understanding that the commission has already ruled on SIGFUR's motion to strike this testimony, we would just for the record renew our objection to David Williamson's second supplemental and corrected second supplemental testimony.
All right, the SIGFUR objection is noted for the record. And I will allow the second supplemental testimony of public staff witness David Williamson, filed in this docket on June 27th, 2023, consisting of 9 pages, will be copied in the record as if given orally from the stand. The exhibits to that testimony, which were corrected on June 28th, 2023, the 3 exhibits to that testimony, which were corrected on June 28th, 2023, shall be marked for identification as they were when pre-filed. And I'll take a motion on that subsequent to your witnesses' participation in the hearing this morning. All right. Okay, anything else, council, before we move on? Go ahead, Ms. Kress.
Chair Mitchell, as it pertains to Sigford 2 witness Collins, I just wanted to get a little bit of guidance from the commission in terms of the scope of the direct examination that I might be permitted to engage in this morning. We are hoping that the commission might allow us with leave to conduct very limited direct examination for the purpose of laying some foundation as well as answering some questions pertaining to the Sigford 2 partial rate design stipulation, as well as the David Williamson second supplemental testimony in order to put Sigford in as close of a position as possible to if that testimony had been filed prior to the evidentiary hearing conducted in this case.
Public staff would object to any direct testimony from Sigford witness on David Williamson's second supplemental testimony. Sigford has had the opportunity to file testimony on rate apportionment in this case and has failed to do so. At this point, it would be inappropriate.
But Chair Mitchell, we did file testimony on revenue apportionment, but the point is that had this testimony been filed before the evidentiary hearing was conducted, Sigford's witnesses, to the extent they took the stand, would have been able to respond to it and otherwise address it during the course of that hearing. And not having had the opportunity to do that, Sigford 2 is simply requesting the opportunity to briefly address it. And by brief, I mean a couple of questions brief here today, since he's already here from Missouri.
So, Ms. Kress, this is what we're going to do. The purpose of today's hearing is to attempt to put the parties in a position, in the same position they would have been in had the evidence been timely filed according to the commission's procedural schedule in this docket, and in advance of the expert witness hearing earlier this year. So the public staff and the public staff and Sigford would have been subject to the same filing deadlines, the same timeline in the proceeding. So I'm not going to allow you to elicit any direct from your witness as a result. And the opportunity to redirect your witness may give you an opportunity to get testimony in should your witness be asked questions on cross-examination. With that, any additional?
Yes, Chair Mitchell, and just to make sure I understand, no direct examination as it pertains to both issues or just the David Williamson second supplemental revenue apportionment issue?
So is your request is your request related to both issues?
It is.
Okay.
So I just want to make sure I understand. Is it that your ruling?
The scope, yes. So the scope of my ruling would be the same on either issue. The idea is we want to put you all in the same position you'd have been in had all of this evidence come in accordance with the procedural order we issued in the docket.
Understood.
So that's the intent. You all can sort of help me work through that as we move through today, but that's my decision on your motion.
Understood. Thank you.
Okay. All right. So with that, if there's nothing further in terms of preliminary matters, let's go ahead and move forward. And Sigford, you may call your first witness.
Thank you, Chair Mitchell. At this time, Sigford 2 would call to the stand Brian Collins.
All right, Mr. Collins, good morning.
Morning.
If you would, please, sir, raise your right hand, left hand on the Bible, or
Sorry.
swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
I did.
All right. All right, Ms. Press, you may begin.
Thank you, Chair Mitchell. Good morning, Mr. Collins. Could you please state your name and business address for the record?
Yes, my name is Brian C. Collins, and my business address is 16690 Swingley Ridge Road, Chesterfield, Missouri.
Could you please state your title and place of employment?
Yes, my title is Managing Principal and my place of employment is Brubaker and Associates Incorporated.
And on whose behalf are you testifying today?
I am testifying on behalf of SIGFR 2.
And did you cause to be filed in this docket a letter on July 11th, 2023, identifying you as the witness who would appear today and attaching your expert witness qualifications?
Yes,
And are you the same Brian Collins whose qualifications were in fact attached to that letter?
I am.
Thank you, Chair Mitchell. Mr. Collins is available for uh, commissioner questions and questions on commissioner questions. I'm sorry, since there was no direct testimony that Mr. Collins.
Our order issued on July 6th directed the company and the public, or I'm sorry, SIGFR and the company to put up a witness in support of the stipulation. We're going to let parties go cross-examine your witnesses, elicit from your witnesses testimony on the stipulation. So
Understood.
that's what we're going to do. We'll proceed with cross-examination. I haven't been provided any indication of who has cross-examination for the witnesses and that proposed time. So I hope you all have worked through that. And who's up first? All right, Mr. Prathan, how much time do you have? Just trying to keep things moving and straight here.
I have probably two questions.
Perfect. All right, you may proceed, sir.
Thank you, Chair Mitchell. Mr. Collins, Marcus Trason, I represent CUCA. Good morning.
Good morning.
I assume that you have read the second supplemental testimony of Mr. Williamson for the public staff.
Yes.
Okay. And with respect to the distribution of revenues that he describes in his testimony, on page 5 of his testimony, he refers to the 4 principles that the public staff uses to the extent possible in portioning revenue. Are you familiar with that on page 5?
Chair Mitchell, can I get this in front of the witness just so he has a? Was this the corrected or the first filing?
First one.
Counsel, do you want to see
Yes.
what I'm?
And I would just ask the chair for clarification. He seems to be asking questions on Mr. Williams' testimony. I believe we're just asking him questions on the stipulation.
That's right. So we're going to address the SIGFR partial rate design stipulation first. So are your questions?
They are not. No, they're
Okay.
related to the
Second supplemental
Second
testimony.
supplemental.
Okay, so hold your questions. Hold your questions. And we'll address that and let's hold your questions for now. For now, we're going to, the purpose is to cross-examine this witness who is proffered in support of the SIGFR rate design stipulation.
Apologize for jumping the gun on that. I do not have any questions for this witness with
Okay.
respect to me.
Let's do this. We're gonna recess. Not yet. I want you all to get together, parties, get together and work through this. You've now heard from me what the purpose of today is. Work through this, work through who you're putting up, how much cross-examination you have. You've heard my ruling that we're not going to use our time today to elicit direct testimony. The commission scheduled, I know this does not come as a surprise, but clearly it merits saying again, is full and busy right now in particular. Please get together, work through this, get organized so that we're not sitting around here floundering. We're now 20 minutes into this hearing and this is too disorganized, especially since you guys have had since July 6th to get ready for this. So please get it together. We'll take 5 minutes and then we'll come back. All right, we're off the record until 10:46. Mr. Drack, what's the plan? We're back on the record, please, ma'am.
Thank you, Chair Mitchell. Parties have discussed, and thanks to help from commission staff, we have gotten to a common understanding, I think, of the approach with respect to the witnesses supporting the settlements, which will be limited cross-examination solely with respect to the settlement. I think we have a very small amount. And then we've also discussed generally proximate timing for cross-examination with respect to David Williamson's supplemental testimony. And I think the estimate is right about 60 minutes worth of cross-examination in total estimated by parties for David Williamson on supplemental testimony.
Okay. All right. Thank you, Mr. Drack. All right, then we will, who has cross-examination for Mr. Collins on the rate design, for partial rate design stipulation?
Yes, so Chair Mitchell, I understand that we're not taking questions with respect to Mr. Williamson's second supplemental testimony for this particular witness. So I don't have any further questions.
Okay, thank you, Mr. Trathan. Thank you for making that clarification for purposes of the record. Any other cross-examination for the witness?
No.
All right. Mr. Collins, walk us through the SIGFR rate design partial stipulation.
Could I get a copy of that in front of him, Chair?
Please
Mitchell?
do.
Yes, the main thrust of the rate design stipulation is in section 2, paragraph A. And basically the company and SIGFR 2 have agreed that any increase in energy charges resulting from an increase in DEP's revenue requirement will be recovered from the LGS time of use, and LGS RTP rate schedules as determined by the final commission order. Shall be limited to a percentage that is less than half of the approved overall increase percentage to those rate classes respectively.
All right, thank you, Mr. Collins. So then what does that mean in terms of the amount of revenue requirement that is apportioned to that class of customers? Does it change the amount of revenue requirement that's apportioned to that class of customers?
It does not. The rate design will recover the commission approved revenue requirement for those classes.
So then I assume because you're limiting, and make sure my assumption is correct, because you're limiting what goes into the energy component, the rest goes into the demand component?
That would be my understanding, yes.
Okay. And so just so I'm clear, the agreement that SIGFR has entered into with the company does not change the amount of revenue requirement that is allocated, revenue requirement increase that's allocated to that particular class of customers.
That's correct. The rate design will recover the appropriate amount of revenue approved by the commission. So there will be no interclass issues with this rate design.
And by interclass issues, you mean as a result of the stipulation, no other class is being asked to pick up any amount of that increase that the large customers would not be picking up.
That's correct. The rate design only applies on an intra-class basis within those classes.
Okay. Let me see if there are questions from commissioners. All right. Questions on commissioners' questions? Okay. All right, Mr. Collins, you may step down. Thank you for your testimony, sir. We appreciate it.
Thank you very much.
All right. Let's see, DEP, you may call your next witness. Or
Thank
you
you,
may
Chair.
call your witness on the SIGFR redesign partial stipulation.
Thank you, Chair Mitchell. At this time, I'd like to call to the stand Mr. Jonathan Byrd.
Good morning, Mr. Byrd. Let's go ahead and get you sworn in again, if you would. Let's raise your right hand, left hand on the Bible. You swear the testimony you're about to give should be the truth, the whole truth, and nothing but the truth, so help you God. All right.
Thank you, Chair Mitchell. And we will just cut right to the chase here. Mr. Byrd, you've previously appeared before this commission in this evidentiary hearing, correct?
Yes.
And today, the purpose of your appearance for the commission is to support the SIGFR partial rate design settlement, correct?
Yes.
And Mr. Byrd, can you, you heard the description of the settlement from previous witness, SIGFR witness Collins. Is there anything you'd like to add or any additional context or color you'd like to add with respect to the settlement?
Just one, we were talking about no interclass. So specific to that, we're looking at its individual schedules as well. So the dynamic of moving energy versus other charges would be constrained within, say, the LGS schedule or LGS TOU. So those are also, that's the way we think about it from rate design. The settlement only speaks to how things are moving around within that particular schedule.
Thank you. With that, Chair Mitchell, witness Mr. Jonathan Byrd is available for cross-examination.
Okay, who's got cross-examination for Mr. Byrd? Go ahead, Ms. Kress.
Thank you, Chair Mitchell. Mr. Byrd, do you recall in the comprehensive rate design study, was there any discussion about capacity-related costs being recovered through demand charges?
Yes, we did talk about that during the comprehensive rate design study.
And can you share what that discussion concluded?
Sure. At a high level, we looked at cost of service and determined that it would be appropriate to increase the amount of fixed cost recovery through demand charges relative to energy. We wrote about that in the roadmap, and so the company proposed, in this case, our original proposed rates, particularly for LGS TOU, increase the amount of fixed cost recovery through demand charges.
Thank you. Nothing further.
Mr. Byrd, good morning. Marcus Strafen for CUCA. Just a couple of questions here about the mechanics of this stipulation. So as I understand it, you agree that this has no impact on the revenue requirement allocation, correct?
I agree.
This has to do with rate design.
Correct.
And under the stipulation, energy charges are limited to a percentage that's less than half of the approved overall increase for the particular rate class. Is that correct?
That's right.
And it's exclusive of any respective decrements. What do the decrements refer to?
Like EDIT or other such decrements. Yeah.
Okay. So if there was an overall revenue requirement increase for LGS of 8%, the energy rate couldn't increase by more than 3.9%. Is that how that would work?
I would say it could not increase by more than half. So if it's 8%, the 4% increase on the energy. That's the way we're reading that.
Okay. So it couldn't increase by more than 4% in that example.
Correct.
Okay. And so the natural impact of that is that the demand component of the rate will go up.
So the settlement says energy versus the overall class. So we think about all other charges, but naturally demand would be the one that would pick up the predominant share of that difference. That's correct.
Okay. So while there is not any interclass subsidization going on, there are winners and losers within the particular rate class, correct?
So I'd say two things. One, the company's proposed rate designs for LGS TOU already conformed to the settlement. So we don't have to change a thing about LGS TOU. It was there. We were raising demand and keeping low. There were actually a decrease on energy for LGS TOU. It's consistent with cost of service, consistent with what we did in the comprehensive rate design study. For LGS, there's a slight tweak on how we would allocate the revenue requirement increase. We put a little bit more towards demand, more than likely, and pull a little bit less from energy just based on what we just talked about there. But it's a very small amount. So based on the company's proposed rates, it would move from high load factor to low load factor customers. That range, if you think about Read Exhibit 5 showing typical bills, it's like 0.3, 0.4% difference there. So it does move around a little bit, but it is between, say, high load factor, low load factor customers.
Okay, so I think you were agreeing with me then, correct, that there is a rate impact and it differs depending on your usage characteristics.
It does. It's in alignment with cost of service. As I said, we are increasing the fixed cost recovery through demand charges in alignment with cost of service.
Okay, and CUCA members would include folks that take under LGS, correct?
I think, I'm not familiar with all of the accounts on there, but I think that's correct.
Okay, and Duke did not consult CUCA with respect to the settlement, correct?
I did consult with CUCA after the settlement. We described to them the implications of the settlement, answered any questions they had, and offered to address any further questions that they might have, but we did not receive any further questions.
Yes, okay. And with respect to the second component of the stipulation in or section 2B, help me with this. So the terms of the settlement also apply to customers currently taking service under the LGS tariffs who switch tariffs to either HLF or the HP tariff. So as I understand this, a customer that's on one of the LGS tariffs who migrates to either the revised HP tariff or the new high load factor tariff could also benefit from this rate treatment. Am I reading that correctly?
So for HLF, there are no customers. It's a newly proposed tariff. There are no customers on that tariff today. And so that rate design is independent of LGS and LGS TOU. When I look at that, I just think there are no implications at all to the HLF customer who would migrate subsequently.
You anticipated my question. That's what I was trying to get at.
Okay, and then if specifically to HP, for a customer on hourly pricing, we establish a baseline for that customer, and for energy under that baseline or for that baseline, they're charged on either LGS or LGS TOU. And so to the extent we had rate designs on LGS, LGS TOU would apply to that baseline for the HP customer. So that's really nothing new. I think that statement just says there's no impacts to the contrary for HLF or HP.
Well, so I think you answered with respect to the new tariff HLF, this settlement really doesn't change anything. There's no application. With respect to the HP tariff, I think you said that there would be some application. So is there a scenario?
Mr. Trathan, let me interrupt you.
Yes.
Mr. Byrd, you just answered, Would you please clarify what that response is for purposes of the record?
Yes, I'm sorry. I think he asked that.
Let's do this. Will you ask the question again, please, Mr. Trathan, and then Mr. Byrd, you give the answer again. Thank you.
I'll try. So I believe that you agreed that with respect to the new HLF tariff, the new high load factor tariff, that this settlement that's described in section 2A has no applicability since these are new rates.
That's right.
Okay. And with respect to the HP tariff, which is being revised, is there a scenario under this settlement where some group of customers are being charged energy rates which benefit from the settlement, and other customers under the HP tariff are being charged energy rates under the regular tariff?
Let me try to answer the question by describing how HP works again. So hourly pricing is a new tariff, and the settlement would not impact the way hourly pricing is constructed at all. All it does, to the extent we change the pricing at all on LGS to conform to the settlement, and a customer goes on HP and they want their baseline, the baseline to be charged at LGS, we would apply the LGS tariff to that baseline. So customers on even RTP and HP, what's below their baseline is billed at either LGS or LGS TOU. So because of that, if you're on RTP or HP, there are implications based on the LGS and LGS TOU designs.
Thank you. That's helpful. That's all I have.
All right, any additional cross for the witness?
No questions from the public staff?
Okay, redirect.
No, Chair Mitchell, no redirect.
All right, questions from commissioners? All right, I've got a few, Mr. Byrd. So, okay. Mr. Trathan elicited some testimony from you regarding usage characteristics, high load factor versus low load factor customers. Can you just walk me through again how the changes that this settlement would make to the LGS class would affect high load factor customers and how it would affect low load customer factors?
Sure. So
Low load factor customers.
low load factor customers. So when you put more through the demand charge, that typically reduces rates for high load factor customer and slight increase to low load factor. So I looked at with witness Reed, Reed Exhibit 5, and when we take the settlement into consideration, we looked at I'll give you an example. We looked at a 5 megawatt customer that had a 41% load factor, and that customer pays about $160,000 bill per month. The slight modification to LGS would result in an increase to that low load factor customer of about a little under $500. So that's the relative scale. And then if you're a higher load factor customer, the inverse would have to happen because for the LGS schedule, it's a neutral revenue change.
Okay, so is it your testimony then that the change set forth or let me say it this way. Is it your testimony that the agreement set forth in the stipulation might reduce the bill for the high load factor customer, and might increase the bill for the low load factor customer, but but those changes in the bill aren't material?
It's small and it's also in alignment with cost of service. So that's directionally, appropriate given what cost of service would say for fixed cost recovery through demand charges.
Okay, understood. So to Mr. Trathan's questions to you about Section 2B of the settlement, which indicates that or provides that the terms of the settlement apply to any customers taking service under an LGS, LGS TOU, or LGS RTP rate schedule who switch to either the HLF tariff or the HP tariff in the event the tariffs are approved by this commission. So, so we know that there are currently no customers taking under HLF, as Mr. Trathan established through testimony he elicited from you. There are no customers on HLF. It's a new tariff. So the HP tariff, there are customers taking under HP. What happens to their, let me ask the question this way. For customers who are taking service under HP, how will their bills compare to a customer who switches to HP?
So let me correct, there are no customers on either HLF or HP.
Okay.
What we proposed in this case is there are customers on RTP.
So is HP new as well?
HP is new.
Okay, sorry, that's just my fog. All right, well then you can just forget all those questions. Okay. So, all right, so then I'm just thoroughly confused by the cross-examination that Mr. Trathan conducted with you. So just walk me through it again. Since I've got you here, help me understand sort of what point he was trying to have you make.
I'm not sure. When I look at Section B, I think it just says that we're making some modifications or the settlement speaks to LGS and LGS TOU, and that there's not supposed to be any impacts that follow on from that to HLF or HP for customers who are on those tariffs and then switch. And so I think it's, to me, obvious that would be the case, because when I look at when I look at HP, I'm billing that below the CBL on either LGS or LGS TOU. So it has to work that way because it's pointing back to those schedules.
Okay. Okay, I'll have to continue to think about this one. Any other questions from commissioners? All right, questions on commissioners' questions. We will start on this side of the room. Okay. Mr. Durack.
No questions.
All right, Mr. Byrd, thank you for your participation this morning. You may step down and be excused.
Thank you.
Public staff calls David Williamson.
All right, Mr. Williamson, good morning.
Good morning.
You remain under oath, but let's just go ahead and get you sworn in just so the fog can dissipate. Please raise your right hand, left hand on the Bible. You swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
All right. Go ahead, Mr. Josie.
Can you please restate your name, position, and business address for the record?
My name is David Williamson, and I'm an engineer with the Public Staff's Energy Division, and my address is 430 North Salisbury Street, Raleigh, North Carolina.
She calls to be pre-filed in this docket on June 27th, 2023, testimony in question and answer form consisting of 9 pages and 3 exhibits.
That's correct.
And did you call to be filed on June 28th, 2023, corrections to your pre-filed second supplemental testimony exhibits?
I did.
And other than those corrections, do you have any additions or corrections to your testimony?
Not at this time.
And if I were to ask you those same questions today, would your answers be the same?
They would.
Okay. And I believe we've already moved for his testimony to be in the record and his exhibits to be pre-marked, so he is now available for cross-examination and commission questions.
So here's what we're going to do. We're going to start first with cross-examination on the witness on the SIGFR partial rate design stipulation. If there is no cross-examination, we'll move to questions from commissioners on that issue.
Thank you, Chair Mitchell. Mr. Williamson, Marcus Strathan for CUCA. Have you had an opportunity to review the partial stipulation between DEP and SIGFR with respect to LGS?
I've read the document, yes.
And do you have a position with respect to that stipulation?
So the public staff generally opposes the stipulation on the grounds that this is kind of constricting the rate designer's ability to appropriately figure out how the revenue requirement that would get assigned to that class, how to appropriately acquire that revenue requirement from those customers, from the energy and demand components. Hearing witness Byrd a second ago, he did say that it aligns with cost of service, but I would say that the intention is for the rate designer to come up with that and not have parties come to an agreement on how the revenue apportionment should be decided and with regards to a rate case. And so that's generally the position of the public staff, is to allow the rate designer the freedom to be able to come to that conclusion based off the cost of service that's being applied.
And so, Mr. Williamson, you alluded to Mr. Byrd's testimony that the stipulation aligns with cost of service. Do you take issue with that testimony?
Objection. This is a friendly line of cross-examination.
He referred to the testimony. I'm asking whether or not he agrees with it.
I'll overrule it. Go ahead.
You asked the question again?
Certainly, yes. You referred to Mr. Byrd's testimony with regards to stipulation, that the stipulation generally conforms with the cost of service principles. Do you agree with that?
I don't know if it conforms completely, but it might be moving things in the right direction. The stipulation kind of predetermines based off a percentage of increase, but the commission hasn't ruled on a final revenue requirement and how much the actual percent increase would do. So it's kind of unclear kind of how the total buckets for demand and energy costs would swing.
That's all I have. Thank you.
Chair Mitchell, I would ask to be able to cross after Kuka since it was adverse to Sigfur's position on this.
Are you indicating that you now have cross-examination for the
I am.
witness? Go ahead.
Two
You may go
questions.
ahead.
Thank you. Mr. Williamson, did the public staff oppose the rate design stipulation that would affect the medium general service rate classes?
Internally, I believe we did, but I think at the time we didn't have the ability to put it in testimony. 'Cause
But you,
it would follow along the same guidelines of the LGS class.
but you did have the ability to put it into testimony for the LGS partial rate design stipulation?
Yes.
How is that possible?
We just filed it with the supplemental testimony that we requested. I mean, I'm not an attorney, but the process would, that from what I saw was that we filed for permission to comment on the settlement testimony.
So the public staff opposed internally the medium general service rate design stipulation, but only opposed externally the large general service rate design stipulation?
So I think our objection was more in general to confining how rate design would get apportioned to individual classes. So as far as whether or not we should have or did file on the MGS, I would say that we probably should have filed to be consistent with our LGS position.
But you didn't, correct?
Correct.
If it's moving things in the right direction, those are your words that I'm repeating back to you in terms of cost of service. Help me understand why the public staff would take issue with that.
So the cost of service is what's being used for the rate designs for the energy and demand. It's my belief that the rate designers should have that freedom and not individual parties that may not represent the entire class.
Okay, no further questions.
No questions.
Okay. Redirect your witness on this issue.
No.
Okay. Let's see. All right, Mr. Williamson. Just help us understand why it's the public staff's position or opinion that rate designers should be designing the rates as opposed to parties or customers that are going to take customers of a particular class. Can you help us understand that?
Sure. So the rate designer is going to have the most understanding of how the load shapes are working for individual classes that encompass all the customers within that class. So they have the best position to be able to adequately price energy, demand, the basic facilities charges, any other fees that go along with it. When the company files for a rate case, they are filing to update any charge that may be applied to a customer, and this is just a piece of it. And so as far as the revenue requirement that gets divvied out between the basic facilities charge, the energy charges, and demand charges, we think that it's more appropriate for the rate designers to get to that level as far as understanding the individual load shapes of all of the customers within particular classes.
And is that because, so just kind of following your position, the public staff's position to a logical conclusion, does allowing the rate designers to have a comprehensive view of all of the customers in the class and then all of the customers in all of the classes that the utility is serving, do those result in rate designs and therefore rates that are more just and reasonable? Or what is the conclusion, or what is the ultimate reason for the public staff's position?
Sure. So they have the best ability to understand how cost of service is playing into being able to recover all of those costs from how the costs were incurred in the past, or at least during the cost of service study that's applied in a general rate case. And so they have the ability to align or progress closer towards alignment with the cost of service that's being applied.
And is it the public staff's position that's ultimately a preferable outcome because it results in rates that align with cost causation and are therefore just and reasonable?
That's correct. And then the public staff, we generally don't get to that level in our review. We try to stay at the revenue requirement for each class of customers so that it allows the rate designer the freedom to be able to do that work.
And who are the rate designers?
So the company ultimately is going to be the creators of these rates. However, there's a lots of conversation. Take, for example, we had the comprehensive rate design study to where all of this work was being done in order to understand and migrate and understand the needs and the wants of different rate classes. And so they're the company, in this case, DEP personnel are going to be the ones that are creating these ultimate rate charges or energy charges or demand charges. And just like in their original case, they propose based off of their revenue requirement, energy charge, demand charges, based off of their revenue requirement. And every time the revenue requirement changes, those energy and demand rates are going to change in accordance with that approved revenue requirement.
Okay. Help me understand the public staff's position on the SIGFR partial rate design, partial stipulation.
So I guess the public staff is just wanting to ensure that, again, freedom is maintained with the rate designer so that rates can be determined as close to cost of service as possible without having it be predetermined before it even gets to the rate designer's hands. Because in this situation, like with Witness Bird, like he was saying, how it's in alignment, that may not be the case in other rate cases, and it might have a different kind of constraint as far as how energy and demand is being constrained in other cases. So it's just trying to keep it in the hands of the rate designers as much as possible.
Okay, thank you for your response to that question. Does that mean the public staff opposes the rate design that the company and SIGFR have entered or have agreed to?
We opposed the stipulation with regards to coming to an agreement on how the revenue requirement should be apportioned. It may align already with the existing cost of service, but it's more towards the predetermined nature of the stipulation.
Okay. Would the public just based on what I'm hearing from you this morning, it would be my assumption then that the public staff would oppose any agreement between Duke and a party or a customer class regarding rate design. Is that the case?
As far as creating a new rate design or coming together to, like I said, to create a new class or a new rate element, I think there is space for conversation there. But as far as predetermining the amount that can be recovered from certain components of a rate class, I think that's where our hesitancy is.
So what would the public staff have the commission do with respect to this stipulation that we're talking about this morning?
believe the public staff's recommendation would be to not allow the stipulation and let the rate designers come to the conclusion that it comes to. If it comes to the same conclusion, then we would support it, but to not have it be a predetermined factor in the calculation, as far as predetermining what the rate designer is able to do.
Okay. Any questions from commissioners? Okay. Questions on commissioners' questions? We will start, Mr. Dirac.
No question.
Okay. Over here. Go ahead, Ms. Kress.
So just to clarify, the rate designer is the company. And the company is the one who not only entered into the stipulation with SIGFR, but also sent a witness here this morning who said that this stipulation will help to better align rates with cost of service. Correct?
That's correct, but if that is the situation, then a stipulation isn't needed because the rate designer would have came to that conclusion on its own.
And so the rate designer, your words, really it's just the company. The company did come to that conclusion because it entered into the stipulation, correct?
I can't really state what happened between SIGFR and the company when they were making that stipulation, as far as what was given, what was taken.
And just to be clear, there's nothing in this stipulation that says that it would apply to any other rate case or any other docket or future proceeding, correct?
I don't believe so, but it's more for clarity in the future that the rate designers be given the flexibility.
Is it fair to say the public staff simply disagrees on principle, but doesn't actually disagree with the underlying rationale for this stipulation?
Well, the rationale, from my understanding, is that it's fixing what the rate designer would be able to use in formulating the energy and demand rates.
And that, as you've already testified to several times, is directionally in alignment, closer to alignment with cost of service, correct?
It can be in this situation, and I think that based off of what I've seen, it is in alignment. However, it's the process of fixing how energy and capacity, energy and demand rates in a rate case based off an agreement between two parties that may or may not encapsulate the entirety of the customers within a class. I think the public staff is generally in disagreement with that.
Does the public staff still generally support rates based on cost of service?
So it's a combination of cost of service and the policy that's currently invoked with the North Carolina law.
And by policy, what do you mean exactly?
So there is the current general for a rate case. There's several statutes that cover general rate cases in general. And so you can go back to my second supplemental testimony. I don't know if we're in that situation yet, but in my second supplemental testimony, I go into all of the different policy factors that come into how to apportion rates, but we're going a step farther into how to divvy up the individual rate components of a rate class's tariff.
And which policy specifically are you talking about this morning with respect to your opinion on the stipulation?
The policy of North Carolina with regards to how general rate cases are upheld, previous commission orders, HB 951. There's a lot that goes into consideration, like I've highlighted in my second supplemental, in my first supplemental, and in my direct, on what needs to be taken into consideration in order to get down to a class level revenue requirement.
Okay, thanks.
Just a few. What would happen if multiple parties entered into stipulations in future cases to lock in individual rate elements in various rate schedules?
if a number of different customer classes did that, or I guess different parties that contain different customer classes, customer class groups, I mean, you would start to see agreements, again, like I was saying earlier, you'd start to see agreements between certain members or certain customers within a class that would essentially be provided a scenario that benefits them the most without having the ability to consult the other customers that are also in that class that would also be paying those rates. Similar to how Witness Bird was describing how the higher the load factor customers, when you switch to more demand rate charges, you're going to cause the lower load factor customers to increase their rates. While it might not be, a considerable amount of money, it's still skewing how much customers are paying out of the benefit of an agreement that was made between the parties and the company.
So is it safe to say that the public staff does not necessarily oppose the rate design itself, but just the precedent of?
It's correct.
Yeah.
It's more of a principle.
Yeah.
The principle of the matter.
Thank you. No further questions.
All right. At this point, we will move to cross-examination on witness Williamson's second supplemental testimony. So let's see, who has cross-examination on this topic? All right, Ms. Kress, you may begin.
Thank you. Mr. Williamson, if you could turn to your corrected exhibit number 3.
I'm there.
Okay. Can you please explain the 10% band of reasonableness in the context of this exhibit 3, specifically which customer classes would fall outside of the 10% band of reasonableness?
So depending on the rate year, the proposed distribution, only the residential class would be within that 10% band.
Only the residential class and no other class?
So when you're looking at just that one principle, that is the situation that you asked. And so that's the answer that I have to give. But you have to take into consideration all of the principles that were put in 951, and then the public staffs has always advocated for its 4 design principles. And so it's not a situation where one is going to prevail over the other. And like I've said in my previous testimonies, there were challenges in this case that prohibited certain rate principles from being able to be accomplished. And so the public staff in my second supplemental testimony and exhibits, it's applying the rate principles and the highlighted items in HB 951 that are also in my earlier in my testimony in the words part, in addition to gradualism, trying to accomplish a fair distribution of rates and revenues to the customer classes. And so in this situation, we weren't able to get to that 10% band. However, gradualism was kind of the other aspect that I had mentioned a second ago. And with gradualism, as far as all the customer classes making positive, if not sometimes significant movement, getting closer to that band, the public staff was satisfied that in this case, that was acceptable as far as our 4 rate principles, because with this new law, unlike in previous rate cases where when a company would come in for a general rate case, it was unknown when the next rate case would be. However, in this case, it's almost presumed for it to be cyclical. And so we're going to start seeing rate cases filed very regularly, and that would give us more opportunities to make that movement, getting closer towards for some of the classes that are far outside of that 10% band, to make that positive movement, but also incorporate a level of gradualism to where they don't experience levels of rate shock because of the drastic jump that would be required of them.
That was a very long answer to what was supposed to be a very simple question. Could you please confirm that the public staff's position is that strict adherence to the 10% band of reasonableness would achieve the minimization of interclass subsidization as required by 951?
So 951, not an attorney, but 951 to me doesn't say that you must minimize. It says that you should minimize to the greatest extent possible. And so whether or not we hit that 10% band, I don't believe is required in this case, because like I said, you still have to incorporate a level of gradualism in order to ensure that the rate increases that are being applied to customers are going to be fair and reasonable, and make the movement that it needs to in order to set you up for the next cases. Like I said, the expectation is, and I hope I'm wrong, but the expectation is that they'll be filing very regularly to take advantage of this new law of having multi-year rate cases. And so we'll be able to make that movement for customer classes getting closer and closer to being within that band. But a customer being in the band of reasonableness isn't required. It just, they want to minimize as much as possible. And this situation, given the changing cost of service and given the first attempt at a multi-year rate case for an electric utility in the state of North Carolina, this was the most reasonable approach that we could come up with as far as ensuring that the revenue requirement was apportioned in totality to all the customer classes, and that rates for customer classes didn't jump extraordinarily high.
So you answered a different question than I asked. And so I'm going to ask that question again, and hopefully you can answer the question that I'm actually asking. I understand that this is not the recommendation the public staff is making, but it is the public staff's position that strict adherence, again, understanding that's not the recommendation of the public staff, strict adherence to the 10% band of reasonableness would achieve the minimization of interclass subsidization pursuant to 951. Yes or no?
So moving towards that band, I believe, is just as good in a rate case.
Chair Mitchell, if I could ask that you please instruct the witness to answer the question. It is a yes or no. We are going to be here all day if this is, the kind of answers that I'm going to get that are non-responsive to the questions that are being asked.
I would, Mr. Williamson was about to answer your question. I want to hear what he has to say. I don't think he's being non-responsive at this point, so I'm going to allow him to continue his testimony. Go ahead, Mr. Williamson.
So again, the 10% ban is one of the components that are needed in order to come up with rates. We can talk about one particular rate principle, but in this case, we can't. We're not isolated to one principle. We have to talk about all of the factors that go into all the policy, all of the gradualism that must be taken into effect. We just have to understand that everything that's in front of us is needed in order to come up with what the commission can rule on in a case in order to determine what rates are just and reasonable.
Are you aware that the word gradualism does not appear in 951 anywhere?
So I'm not aware, I guess I'd have to answer that as a subject to check. I'm not aware that gradualism is specifically labeled in HB 951, but HB 951 is not the only law or precedent that's being applied in this case, to my knowledge. 951 is just the structure for how a multi-year rate case should be handled.
Thank you. At this time, Chair Mitchell, I'd ask to please have an exhibit identified and marked for the record and be passed to the witness after council has an opportunity to take a look.
All right, let's go ahead and get it marked, Ms. Kress.
Thank you. Chair Mitchell, we'd request that this be marked Sigford 2, Williamson, second supplemental, cross exhibit 1.
All right, the document will be marked as Sigford 2, Williamson, second supplemental cross-examination, Exhibit 1.
Thank you.
Actually, yeah.
Mr. Williamson, to help you answer the question that I tried to ask a couple of times, if you could turn with me to the public staff's response to data requests 112 on the very last page. Can you please read that response into the record?
Sure. So D. Williamson's first supplemental exhibits were provided for illustrative purposes only, while strict adherence to the 10% band of reasonableness would, from the public staff's perspective, achieve the minimization of interclass subsidization as expressed in 951. It would also result in significant rate shock for certain classes of customers. Public staff proposes its 4 guiding principles to provide a level of structure for rate apportionment. All 4 principles work in tandem, and in many cases, it is impossible to satisfy all four for every rate case. In cases where it is impossible to adhere to some of the principles to avoid significant rate shock, gradualism is the appropriate approach to take.
Thank you. And if you could now turn with me to the public staff's response to Sigford 2 data request 1-11 on the previous page. And you'll see that that data request says, provide the subsidy level paid/received by each class that corresponds to Williamson Exhibit 3. Could you please read the public staff's response to that data request?
Sure. Says this request seeks the production of documents that are not in the public staff's possession. Public staff objects to this request because it would require the creation of new work product that does not currently exist.
Can you help me understand how the public staff can opine that your recommendations contained in your second supplemental testimony and exhibits minimize to the greatest extent practicable interclass cross-subsidization in this rate case when the public staff didn't even calculate the interclass subsidies at issue?
So on a dollar value, we didn't calculate the interclass subsidies, but as far as a rate of return value, those values were provided as part of, I believe it was Williamson Exhibit, corrected Exhibit 3, like we were looking at a little bit ago. And so that is what we used as the guide to understanding how each rate class is moving progressionally with minimizing its interclass or its subsidization that's being provided. So we use that as our guide to understanding how cross-subsidization was being taken into account and ensuring that positive movement was being made.
Okay, let's talk about how the public staff's position on this issue, that being revenue apportionment, changed from your first supplemental testimony to your second supplemental testimony. So why don't you tell us in your words what changed and why?
So I don't believe anything changed as far as the considerations that I took in when creating the revenue apportionment for each rate class. Like my first supplemental testimony stated, it was for illustrative purposes. This rate case, one of the goals of the public staff is to inform the commission on our findings of what we see as notable and things that we believe you should take into consideration. And so with this, for illustrative purposes, we provided in the first supplemental, I think it was 4 different scenarios that the commission could take into consideration of if we took this approach, what would the rate impacts be? If we took this approach, what would the rate impacts be for all 4 of the rate years, or the base case and the 3 incremental rate periods? But and so for illustrative purposes in that instance, we try to inform the commission as much as possible about the challenges that not only the public staff were experiencing, but the challenges of trying to make rates for 3 rate periods, but 4 different years. It's confusing. It's 4 periods, 3 rate years. Come together in a manner that would produce fair and reasonable rates as far as an increase to each of the customer classes. But in the second supplemental, this is our approach to satisfying the revenue requirement while also accomplishing all of the rate principles and 951 to the greatest extent that's possible. And that's our position on the matter.
So is it your testimony today that the public staff's methodology for calculating revenue apportionment between customer classes did not change from your first supplemental testimony to your second supplemental testimony?
Well, it was 2 different situations. The second one, which is our final proposal, our only proposal actually, provided the best approach to incorporating gradualism. In the first supplemental, there were customer classes that were going to experience an increase that was just public staff's opinion not attainable. Specifically looking at the lighting classes, they were going to experience drastic rate changes. And so that doesn't really apply a level of gradualism that we believe is required when the commission sets its final order on the rates that should get distributed to the customers. And so in this instance, we believe that the second supplemental methodology for apportioning the revenue requirement is reasonable, and we believe that the commission should apply this methodology in this case.
And now the public staff produced in discovery its work papers associated with both your first supplemental and your second supplemental testimony, correct?
I believe so.
Chair Mitchell, if we may pass out another exhibit. And council first. And if we could request that this be marked Sigford 2, Williamson, second supplemental, cross exhibit 2.
All right, the document will be marked Sigford 2, Williamson, second supplemental cross-examination, exhibit number 2.
Can Mr. Crust specifically identify? Okay, worksheet. Which worksheet this is?
Sure. So in what has already been identified as Sigford 2, Williamson second supplemental cross exhibit 1, the public staff provided some work papers, and Mr. Williamson just testified to the fact that the public staff provided work papers both for his.
Actually, Ms. Cross, I'm going to stop you. put this in front of the witness. Ask the witness if he recognizes this document. If he doesn't, then that will provide the commission with some guidance on the weight to give the evidence that the witness provides on this document.
Mr. Williamson, do you recognize the methodology that is contained on the bottom half of the front sheet of paper that has red, blue, green, and orange boxes?
I do. It's kind of a description of what these other individual tabs that are cut off. But it's a description of kind of what's going on in this situation.
Is it also the instructions for the public staff's methodology for revenue apportionment that was contained in the very first tab of the public staff's work papers underlying your first supplemental testimony?
It was. And so I guess what I have to say about this right here is that the public staff has to be able to model its own revenue requirement apportionment. It's the only way we can really go and double check what has been provided by the company as far as our own independent analysis to determine whether or not they have come close or how they might have modeled things, because this is the preferred model or underlying model that the public staff has used for years. I had to modify it slightly because typically it's a 1-year rate case, and so we had to add a lot more tabs in order to incorporate different rate years, but the same principles are still there. And so it's just a means for the public staff to be able to double check, was this the best approach that could have happened as far as revenue apportionment compared to what the company has provided, or if it would give us the ability to play around with the policy of trying to make the positive movement for the different rate principles and the various components of 951.
Would you have any reason to disagree with me, Mr. Williamson, that the metadata for those initial work papers underlying your first supplemental testimony, as snipped on the top half of this piece of paper, reflect that these work papers were an Excel spreadsheet initially created by James McLaughlin in 2004?
I don't have any reason to deny that. That's why I said that we've used this spreadsheet for many years, and we've had to modify it to incorporate a multi-year component.
And if you could flip the piece of paper over, would you have any reason to disagree with me that the work papers underlying your second supplemental testimony indicate that the author is Samita Deshmukh, an employee of Duke's Rate Design and Regulatory Strategy team?
So like my second supplemental testimony said, we had conversations with the company to try and work through apportioning out these revenues. And so the company initiated conversation with the public staff to try and work through what could be done, because they understood that there were challenges as well in trying to apportion these revenues and create the rates. And so there was conversations with the company, and at some point in time, I don't remember the day, but at some point in time, there was a file that was provided that the public staff agreed with as far as a reasonable approach to apportioning these revenues, and the impacts of that document are what's reflecting in my 3 exhibits in my second supplemental. We agreed with that apportionment as a reasonable apportionment strategy for this case, and so there wasn't a need to go back and recreate the methodology when we were already in agreement with the company on the methodology that we had had conversations on.
And so just to be clear, that's a different methodology than the public staff's initial methodology underlying your first supplemental testimony that is reflected in the colored tabs on the front of this document.
So the methodology is different. They accomplish the goals to the public staff's satisfaction as far as the second supplemental. We agree with the methodology that the conversations that the company and the public staff had. And as far as the difference between the first supplemental and the second supplemental, the first supplemental was, again, the public staff's created document versus the company's created document. So we're going to have our own approaches to figuring out how revenue requirements should be divvied up amongst the customer classes, but that doesn't discredit the work that's being done to apportion those revenues requirements. There's many ways to design the model to apportion the rates, but it's just a matter of are the revenue requirements adhering to the public staff's principles and 951 and any other state policy goals that are in effect at the time.
Let's take a look and see how Duke's work papers compare to the public staff's work papers for your second supplemental testimony. If you could, just confirm with me with Slace and Foundation, if you could confirm with me that in response to SIGFR's data request 1-6 to the public staff, which you should still have that document in front of you, the public staff produced a series of emails. Is that correct?
That's correct.
And is it your understanding that those emails showed some of what you just testified to about how the public staff and the company talked through and reached sort of a meeting of the minds as to the best approach for, in your opinion, revenue apportionment in this rate case?
Yes.
And is it your understanding that the company provided a series of their own work papers that they shared with the public staff during those discussions?
Yes, that's why the support comes from Duke Energy, like you pointed out.
Okay. So if I could, Chair Mitchell, instead of having 4 different exhibits passed around, it's just, there's one for the test year and then one for each multi-year rate plan year. And so I'm wondering if we can just pass them out in one fell swoop.
Please do.
Okay.
Can somebody help? Let's just get him some assistance so we can do this more quickly. Mr. Snowden, Mr. Trathan, one of you guys help him. Hopefully Ms. Kress can stay at her seat so she can be ready to conduct her examination.
Four.
Just wait on him.
All right, Ms. Kress, let's keep moving here.
Okay, Chair Mitchell, I'm sorry, go ahead.
I don't think they witnesses.
Mr. Williamson, you have the documents. Okay.
Chair Mitchell, we would request that the test year page, the one that says partial settlement test year in bold at the top left-hand corner of the document, be marked as Sigford 2 Williamson Second Supplemental Cross Exhibit 3, followed by multi-year rate plan year 1, be marked as Sigford 2 Williamson Second Supplemental Cross Exhibit 4, rate year 2 be Exhibit 5, and rate year 3 be Exhibit 6.
All right, the documents will be so marked. Want to make sure court reporter gets her copy as well.
Mr. Williamson, do you have 4 pages of
I have
exhibits?
5 pages of exhibits.
Okay, is it possible you have a duplicate?
5 pages.
You have 5?
Yeah.
Okay, understood, thank you. In which case, Chair Mitchell, I think I also need an Exhibit 7.
All right, the document that shows ROR as percent of average.
Yes,
Okay.
that's correct.
All right, we'll mark that document as Sigford 2 Williamson Second Supplemental Cross Examination Exhibit 7.
Thank you. Mr. Williamson, would you agree, subject to check, that the documents that were just put in front of you and identified as Sigford 2 Second Supplemental Williamson Cross Exhibits 3, 4, 5, 6, and 7 were the work papers that Duke shared with the public staff leading up to the filing of your second supplemental testimony in this rate case?
That's correct.
Thank you. And now, for comparison's sake, we have the same documents from the public staff's work papers. And so if I may take a moment to try to make this process more streamlined.
Go ahead.
Yes, please. So, just test here, multi-year 1. And then I need.
Sure.
Through that. And just. Him and then shares and the that's going on.
So we'll mark these 8, 9, 10, and 11.
Yes,
All
thank
right.
you.
All right, the document identified as partial settlement test year shall be marked as exhibit as Sigford 2 Williamson Second Supplemental Cross Examination Exhibit 8. Document identified as test year and MYRP year 1 will be Sigford 2 Williamson Second Supplemental Cross Examination Exhibit number 9. Document identified as test year and multi-year rate plan year 2 will be marked as Sigford 2 Williamson Second Supplemental Cross Examination Exhibit 10. And then Document identified as test year and multi-year rate plan year 3 will be marked as SIG for 2, marked for identification as SIG for 2, Williamson, second supplemental cross-examination, exhibit number 11.
Thank you, Chair Mitchell. Mr. Williamson, would you agree with me, subject to check, that the documents just placed before you and identified as SIG for 2, Williamson, second supplemental, cross exhibits 8, 9, 10, and 11 are the public staff's work papers supporting your second supplemental testimony filed in this docket?
Yes, that's correct.
Okay. Are you able to point out to us what changes were made from the company's work papers to the public staff's work papers and why?
So the only change is the additional column that has the blue highlighted cells. The only change is that the public staff put in what the percent increases would be excluding riders. And that's reflected in the public staff's, I believe it was Exhibit 2, the corrected supplemental Exhibit 2. And so, yes, it's the Williamson D second supplemental testimony corrected Exhibit number 2. And on that exhibit, there are 2 sets of percent increases, one that includes riders and then one that excludes riders. And the public staff has generally advocated that a general rate case is designed to adjust rates and only rates related to the base rates. The inclusion of riders provides a skewed picture because riders change more frequently or at different points in time. Let me phrase it that way.
Thank you for that. And Mr. Williamson, are you aware that on July 3rd, Duke caused to be filed in this docket a letter indicating that they support the revenue apportionment recommendations contained in your second supplemental testimony?
I believe that's correct.
And are you aware that that letter also indicates that the public staff's recommendations are consistent with what DEP initially recommended in their pre-filed direct testimony back in October?
I believe that's correct. I don't have the letter right in front of me, but subject to check, sure.
And so, is there any reason why the public staff couldn't have indicated that it supported that same methodology in your first supplemental testimony?
So my direct testimony, we hadn't gathered a revenue requirement. So my direct hadn't gathered a revenue requirement, but we had done a review of each individual principal. And there's a couple pages in my direct testimony that highlight where the rates, quote unquote, failed those tests. And so in the first supplemental, we provided some illustrations of kind of what's going on with apportioning out the rates to try and adhere to the rate principles to the best that we could at that time. But it was illustrative. It was just again, it was just trying to educate the commission about what's going on. And so in the second supplemental, we, after working through our going back to our own revenue apportionment model, and given the challenges that I've echoed in every testimony in this case that we're experiencing with trying to adhere to all the principles as best as possible, at that point in time, we were able to tell that the company had made the best effort to try and apportion rates in a reasonable manner. And so now we're in the situation where we are I couldn't at the time declare that, but now I can say that.
And so looking at these comparisons side by side of the public staff's work papers versus the company's and taken together with the metadata showing that this spreadsheet constituting the public staff's work papers originated with Duke Energy, is it fair to say that the public staff essentially adopted the company's approach and the company's methodology to revenue apportionment?
So we believe that it's a fair approach to use the model that was filed in our second supplemental, and then the company agreed with it in their supplemental letter.
And so with very few exceptions, would you agree with me that exhibits 8, 9, 10, and 11 are almost mirror copies of 3, 4, 5, and 6?
Yes, with the exception of the additional column to exclude the riders and figure out what that percentage would be.
Thank you. Can you explain why total lighting is separated out as its own line item, separate and apart from the rest of the rate classes?
I can't answer that question, but my hope is that it's the company trying to come together and realizing that some of the lighting classes are in need of having some changes applied to them. And so maybe it's the company, and I'm just, speculating here. Maybe the company is trying to work through what it would look like to combine the lighting classes.
And so you can't answer that question, but these are your work papers, correct?
So my recommendation is applying everything that's in the gray. Everything, the total lighting down at the bottom is just, it appears to be a combination of a couple different line items related to the lighting classes.
Okay, and so just to be clear, exhibits 8, 9, 10, and 11 are your work papers underlying your second supplemental testimony, and you can't tell us why total lighting is listed below the rest
So-
of,
My recommendation applies to the shaded area. That's where my focus was.
so what is the total lighting row in your work papers? What does that mean, and what is that denoting?
The combination of line 19 and 22, which is the ALS, SLS, and SFL
And
lights classes.
why is that in your work papers?
Objection, this wasn't in his supplemental testimony.
Chair Mitchell, it's in the work papers which formed the basis and support for his second supplemental testimony that were produced in discovery.
Yeah, I'll overrule the objection and just provide the answer, Mr. Williamson.
Sure. Appears that it was just carryover from the files that the company had provided to the public staff. So that's a question for the company as to why that was down there.
Thank you. I now have some questions on behalf of Haywood EMC, and I'm not sure if you would like me to go ahead and do those now. Okay. Mr. Williamson, are you familiar with these public staff? Oh, I'm sorry, Chair Mitchell, may I please request that this be marked Haywood EMC Williamson, second supplemental cross exhibit number 1?
Correct, document will be marked as Haywood EMC, Williamson, second supplemental cross-examination, exhibit number 1.
Thank you. Mr. Williamson, are you familiar with this document?
I am.
Did you help provide the public staff's responses to these data requests?
I did.
Okay, thank you. If you could turn with me to data request 1-8, please. And this data request states, does it not provide the information contained in D. Williamson's first supplemental testimony exhibits 1, 2.0, 2.1, 2.2, and 2.3, updated to reflect the final revenue requirement number recommended by the public staff. Is that what that data request says?
It does.
And could you state for the record the public staff's response to this data request?
Sure. This request seeks the production of documents that are not in the public staff's possession. The public staff objects to this request because it would require the creation of new work product that does not currently exist. Without waiving said objection and relying specifically thereon, D. Williamson's first supplemental testimony exhibits 1, 2.0, 2.1, 2.2, and 2.3 were for illustrative purposes based on an at the time unknown final recommended revenue requirement. D. Williamson did not update the illustrative exhibits with the known final recommended revenue requirement. Therefore, this request would require the creation of new work.
And could you please turn with me to data request 1-9?
Can I say something first? As far as the reason that we did not produce those documents is because we had already had the conversations with the company and basically agreed to the distribution, so it was not needed to go back and go through that process.
Could you please turn with me to the public staff's response to data request 1-9, which asks, provide a revenue distribution that adheres to the 10% ROR index band to all classes?
Sure. This request seeks the production of documents that are not in the public staff's possession. The public staff objects to this request because it would require the creation of new work product that does not currently exist. Without waiving said objection and relying specifically thereon, D. Williamson's amended supplemental testimony filed on May 4th, 2023 contains illustrative exhibits that show the illustrative revenue distribution based on 10% revenue requirement. Rate of return index band for all classes, exhibits 2.0, pages 404, 2.1, page 404, 2.2, page 404, and 2.3, page 404. D. Williamson did not produce an updated distribution that utilizes the methodology that was applied to the first supplemental testimony for the public staff's known final recommended revenue requirement. Therefore, this request would require the creation of new work product.
Thank you. And finally, data request 1-10, which requests provide a class revenue distribution that eliminates all inter-class subsidies by the conclusion of the proposed multi-year rate plan. And the public staff's response was?
This request seeks the production of documents that are not in the public staff's possession. The public staff objects to this request because it would require the creation of a new work product that does not currently exist. Without waiving said objection and relying specifically thereon, the public staff understands this question to mean that all rate classes should have a rate of return index of 1.0. Please see the illustrative exhibits found in his first supplemental testimony. This request for the final revenue requirement proposed the public staff's second supplemental testimony would require the creation of new work product.
Thank you. No further questions.
No questions.
All right, anything additional from interveners? All right, Mr. Josie,
Thank you.
redirect.
Mr. Williamson, there was a large discussion on gradualism and if gradualism was included in 951. Do you remember that?
I do.
Okay, and what is the purpose of gradualism as we talk about setting rates?
So gradualism with regards to increasing rates is it really just I think I talked about this in the original hearing, is that I don't know if there's a true definition of rate shock, but gradualism is just supposed to try and increase rates at a more gradual nature so that rate shock or a high increase in rates at one given time is not experienced.
Okay, do you happen to have a copy of HB 951 with you?
I do.
Can you turn to, sorry. Part 2, under section 62-133.16 D 1C. I believe you've just got a PDF of the session law. It's page 7.
Yeah, it's my personal copy. It's worn out almost. So yeah, I'm there.
Okay, and could you, you said gradualism is to reduce rate shock, correct?
Correct.
And does D1C of 133.16 discuss rate shock?
It does. It states will not unreasonably prejudice any class of electric customers and result in sudden substantial rate increases or rate shock to customers.
And the 10% band you discussed with Ms. Kress, is that in statute?
It's not. It's just been a guiding principle of the public staff. When statute is unclear, the public staff is just trying to apply a methodology that it can support when defining different rate principles of how to apportion rates. It's not saying that the 10% ban is the only principle, but in conjunction with those 4 principles and law, that's what we've used as a guide throughout the years in rate cases.
Okay, maybe I should back up a little bit. Do the statutes that prescribe how rates are set provide bright line rules that the rate designer must strictly follow?
Not exactly. I mean, just to take, for example, the comments that we've had in this hearing and in the previous hearing is the reducing cross subsidization to the greatest extent possible. That's not very definitive in my mind. That's just saying to make as much movement as you can that's allowable, that's not going to create undue rate shock.
And as to the exhibits, the work papers between that Ms. Kress was asking you to compare between the company's provided work papers and the public staff's work papers, is one significant difference the revenue requirement that's actually apportioned?
Correct.
Okay. And then as for the total lighting line item that she was, or total lighting line that she was asking about, did that have any impact on the public staff's recommendation?
No.
Can you look at your corrected exhibit 2 in your second supplemental?
I'm there.
Okay. Can you tell me which rate class is the lowest percentage increase in rate years 1 to 0?
Objection. This is not responsive to anything this witness was asked on cross.
Setting of rates throughout the multi-year rate plan.
Chair Mitchell, I did not ask a single question about corrected exhibit number 2, and we did not talk about percentage rate increases to any customer class.
I can withdraw the question.
All right, if the question is withdrawn, that spares me from having to rule on that objection. So go ahead, Mr. Josie.
Can you look at your corrected exhibit 3, which I believe was asked about?
I'm there.
Do the ROR indices for the LGS class go up or down compared to the present?
In every rate year, the base case, rate year 0, rate year 1, 2, and 3, the LGS class is making positive movement towards the band, the 10% band.
And just, no further questions.
All right, Mr. Williamson, I'm looking at the cross-examination exhibit that counsel for Haywood EMC put in front of you. Can you get your hands on that document?
Right.
This document doesn't appear to have a date on it. Do you remember when the public staff was served with this document?
It was after your order was issued establishing this whole process.
So meaning it was served on you, or it was sent to the public staff sometime after July 6th?
Correct.
Had the public staff engaged in any discussion with Haywood EMC prior to this data request?
Yeah.
Okay. Okay. Help me understand what is going on here.
I hate to ask for a little clarification.
Just give me your thoughts on
Okay.
what is going on. Why are we here right now?
So unfortunately, the public staff was unable to complete our audit of the costs that are going into this case. The public staff was in the process of reviewing, chatting with Mr. Metz this morning, kind of on this topic. It was, a little north of $400 million that were being brought in during this period. And that requires a little bit of time. And so that was kind of slowing up our process the public staff's process to be able to come up with a final revenue requirement recommendation. Sure.
Do I understand you correctly that the final update provided by the company involved $400 million that the public staff had to audit?
I believe it was north of that. I don't want to know the exact number off the top of my head, but I believe it was north of $400 million, yes.
And that do I also understand you correctly that until you all, public staff, completed your audit of that final update, the public staff could not determine its revenue requirement recommendation in this case?
That's correct.
Okay, let's proceed.
Yep. So we're in a situation where potentially $450 million of swing, whether or not we agreed with all of that or disagreed with all of it. And so at that point in time, we hadn't completed our review. And so a final revenue requirement wasn't put together. And since then, we have worked through a final revenue requirement number. And unfortunately is after the close of the original hearing. And we are here today to discuss, in addition to the stipulations, but we're here today to discuss the final recommendations of the public staff on how to portion out this total revenue requirement, where the company has their total revenue requirement number in mind and the public staff has ours. And the commission will rule on that. And we're in a situation with unclear how the revenues will actually get distributed. But the company and the public staff have worked together and come up with an understanding that the distribution that's outlined in my second supplemental and echoed in the company's filed letter illustrate that how they're intending to apportion out those revenues is reasonable. We just are trying to figure out what that final revenue requirement number is going to be as far as commission approval.
So, let me turn my microphone on. So, sorry, apologies. So the, make sure I understand this correctly. Is it correct that the only difference between the apportionment, those percentages that were included in your, I think it's specifically, the percentages included in the exhibits to your first supplemental testimony and your second supplemental testimony is that in the second supplemental testimony, the public staff had determined its final recommendation on the revenue requirement, and you all included the percentages excluding the effect of the riders. Is that correct?
As far as revenue requirement, that's correct. It's methodology, there's different methodologies to come up with, or there's different interpretations on how you can apportion rates and revenue or revenue requirement, and that just depends on different people's interpretation of the law. But in our situation for the first supplemental, again, that was just illustrative, trying to be educational. We didn't know what our final number was going to be, and so it was a situation where we were trying to educate the commission on what are the impacts that customers are going to be experiencing based off of this increase. And unfortunately, we weren't able to propose a revenue apportionment in the first supplemental that would adequately apportion rates while also not making it seem undue with the rate shock issues that were present.
Okay, so do I understand correctly then that the public staff couldn't settle on its method for apportioning the revenue requirement among the customer classes until it knew what that revenue requirement was?
So with every dollar of revenue requirement that changes, you're going to change how each class is going to be impacted as far as the percent changes. It's the final revenue requirement was essentially the pencils down moment for us, where this is it. This is the final number. We actually know what the playground is, and so then we can focus on where do we stand with trying to incorporate gradualism, trying to incorporate moving these rate of returns for the individual classes closer to the band, making positive movement towards for that, as well as just trying to adhere to the other principles as well, as far as the rate principles 3 and 4.
Okay. So Ms. Kress asked you questions regarding the exhibits that I believe were included in your second supplemental testimony, as well as exhibits that were Duke provided exhibits. Do you remember that?
The supporting work papers.
That's right. I'm sorry. Yes, I'm using the word exhibit in the context of this hearing, but
Gotcha.
yes,
Okay.
the supporting work papers. That's right. So we have a set of Duke's papers and we have a set of the public staff's papers. Is that right?
Correct.
Okay. And walk me through what the difference is between those two sets of work papers.
So based off the conversations that we had with the company, this was sent over to us as far as the first batch of papers, the one that doesn't have blue. That was sent over to us, and we were, through conversations, we were in agreement with that methodology. And so the only difference is the public staff had wanted to continue its request that percent changes be a reflection of excluding riders, because again, we're in a general rate case. It should be based off of the base rates that are in question.
Okay. And these work papers, neither set is dated. Do you know approximately sort of what the date is for these work papers, and my guess is this was ongoing work between the public staff and the company, but for when were these work papers final?
I guess going back, June-ish.
Okay.
Ish is bad, but going back to the cross-examination that Ms. Kress was sending me down as far as the emails, there were two different dates, June 5th and June 26th. So it was not short amount of time. It was a considerable amount of time.
Okay, the data request, the first data request of SIGFR 2 to the public staff that counsel for SIGFR asked you about earlier today in your testimony, it is also not dated. Do you know when the public staff was served with this document?
I know, again, it was after the commission issued its order setting up this proceeding, but it was one day we got this request, and then the next business day we got the Haywood request. I can't remember those dates off the top of my head.
Okay. Okay. Let's see. So is it fair to say, or is it correct? Let me say it this way. Is it correct? Is it correct to say that the public, that there is no disagreement between the public staff and the company on, as to the apportionment of revenue requirement between the customer classes?
That's correct. We are in agreement with the methodology to apportion the revenue requirement. It is just the revenue requirement that remains in question.
Okay. All right. Let me see if there are questions from other commissioners. Okay. Let's see. Joanne, let me know how you are doing. Okay. I will take questions on commissioners' questions. We'll start, nothing from Duke.
question.
All right. Over here, Ms. Kress, you may proceed.
Thank you, Chair Mitchell. When you talked about the discussions that the public staff and the company had in June, leading up to the filing of your second supplemental testimony in this docket, were any other parties to this rate case invited to those discussions?
To my knowledge, it was just the public staff and the company, but the company initiated those conversations, so you'd have to ask them why they didn't invite anyone else.
Understood. And so none of the illustrative examples that you provided in your first supplemental testimony in terms of the methodology, none of those methodologies form the basis of your recommendations contained in the second supplemental testimony you filed, correct?
The principles are still there. As far as how we were modeling the revenue apportionment, that's really the only difference. The public staff built its own model or used its own model that it's used since, as we were stating before, this document dating all the way back to 2004, updated to reflect a multi-year type component. And in that situation, we were trying to come up with an approach, because at the time we were unaware if what the company, because when you do the first analysis in my direct testimony, you can clearly see that I highlight the failures to some of the rate principles. But again, I also state that there are a ton of challenges that are existent in all of this whole process as far as trying to apportion the rates across all 4 of the years or the 3 of the rate years. And in that situation compared to now, the revenue requirement methodology that we're proposing now that, we worked with the company on, we believe that this to be the best, most reasonable approach that can be done in this case.
But your relative ranking of the public staff's principals changed from your first supplemental to your second supplemental, correct?
So they've always worked in tandem. All of the rate principles is just an acknowledgement of whether or not any of the rate principles are achievable. And so but they all work in tandem, like in concert with one another.
So is it your testimony that the relative weighting that the public staff gives to each respective principal did not change from your first supplemental to your second supplemental?
Correct.
So is it your testimony that the public staff applied an emphasis on the second principle?
So all four of the rate principles were taken into consideration when coming up with the rate apportionment that was provided in the second supplemental of my testimony to the greatest extent that they could.
And then can you just help us understand why the public staff didn't just run its final revenue requirement number through its work paper spreadsheet that it's been using since 2004 for your second supplemental testimony?
Because the reason we didn't run it through that model is because we had already agreed with the company on the model that the revenue apportionment that should be applied out of fear of taking away more days before us to file and prolonging this process even farther. We believed it to be not necessary to take that extra step when we were already in agreement with the methodology.
Did the public staff and the company file a stipulation on revenue apportionment?
I believe the only stipulation with regards to rates that we filed was on cost of service.
So the answer then is no, the public staff and the company did not enter into a stipulation on revenue apportionment?
As far as the class level revenue requirements, no.
Would you, since you were asked one question about Haywood, would you have any reason to disagree that Haywood EMC takes retail electric service from DEP under a small general service rate schedule?
I don't know what type of service Haywood EMC takes its power from DEC or DEP, excuse me.
Would you agree, subject to check?
Sure, subject to check.
Great. That's all. Thank you.
Mr. Josie?
No question.
Okay. All right, with that, we have come to the end of the hearing today. Mr. Williamson, thank you for your testimony. You may step down and be excused.
Chair Mitchell,
Yes, ma'am.
a motion, if I may.
Go ahead.
Sigford 2 would request that its Williamson second supplemental cross exhibits 1 through 11 be admitted into the record as marked and identified previously. And then Haywood EMC would move its Williamson second supplemental cross exhibit 1 as previously marked into the record at this time.
That motion will be allowed.
Public staff would move Mr. Williams's 3 exhibits as corrected by the June 28th, 2023 filing.
Sigford will just renew its objection.
All right, noting Sigford's objection, I will overrule it and allow those exhibits into the record. So let me just say this about post-hearing filings. Certainly you all have an opportunity to file post-hearing filings on the issues that were covered today. Mr. Williamson, you may step down if you want to.
Thank you.
However, we need those as soon as possible. So to the extent that you would like to file post-hearing briefs or proposed orders, do so no later than 3 days from the notice of transcript for this portion of the hearing. And emphasis on no later than. So the sooner you get those in, the better it is. All right, anything else from council before we adjourn?
Nothing from DEP.
Nothing from public staff.
All right, with that, we will be adjourned. Thank you very much.